And feel free to get something to drink and a little, we have some snacks, and if you need to get up and stretch your legs, please feel free to do so. We realize that most people never get an opportunity to meet with a judge unless there's a problem. So thank you very much for being here tonight, because there's no problem tonight, right? We're having coffee with the court. So let me tell you how it started. About 7 months ago, I went to a conference, and there was a senior judge at this conference, and I said, "What are y'all doing in the big city of Orlando?" And he starts to share with me, "Oh, we're doing this, we've been doing that, and we're on our 19th year," I think he said, "of this program." And I said, "Well, what is the program?" And it's essentially where the court comes to the people. The court will talk about topics that may be trending or things that you've always wanted to know and didn't. And so that's where this came about, Coffee with the Court. That's how it was born. I contacted our chief judge, Judge Davis, right over here. And when I came back from that conference, and I was just bubbling over with excitement, I thought he was going to tell me, "No coffee for you." And he was just as excited as I was when it was all said and done. And he said, "Go ahead and start planning." So I spoke with our communications director. I think that's her title, but if not, that's the title I'm giving her tonight, Chrissy Kane. And she helped me all through this process. We had Dominique Phillips from Court Administration, who helped do the digital flyers and all of that. We have Mr. Stafford, who's one of our magistrates, and I think half of his class is here tonight. The Judicial Circuit Bar, it was mentioned at one of the lunches by Judge Davis, and we have a number of lawyers that are here tonight. So thank you all so much for being here. Our hospital administrators, there's a few of you. We have some pastors here in town, and then just folks who want to know. So thank you all for being here. It will be a glimpse from the bench. When I shared my view on my idea of what this would look like, I received support from the judges in our circuit. And so tonight's program is really brought to you by all of the judges in our circuit. And in case you don't know how large our circuit is, it is Alachua County, Baker, Bradford, Gilchrist, Union, and Levy County. It's pretty large. And so some of the judges will travel the circuit in terms of maybe one day they're in Baker County, another day they're in Alachua County, and those are the circuit court judges. In short, I wanted Coffee with the Court to be a free, informal conversation with the public on trending topics. And each time we meet, you'll be meeting a different judge, talking about a different topic. And the hope is that we meet twice a year. Maybe the next time we meet is at the end of September, early October, before we wind into the holidays and we won't see any of you. So that's what we're looking at is September, October. Now, a few ground rules for tonight. We have rules that govern our conduct as judges. So first and foremost, we can't give legal advice. We cannot give our personal opinion, and wait for it, we cannot talk about any active or pending cases. Okay? All right. So before we get started, I want to introduce some sitting judges. I know it's been a long day for them. Some of them are still in trial, some of them are still in court. But we have Judge Rawls, if you can just stand up there. And we have Judge Brewer against the wall, Judge Koloff, Judge Ramsey, Judge Ferrero, that's our IT guy over in the blue. And we have our general counsel, Robert Holton, if you could you stand up and just wait for that? All right, perfect. Thank you very much. And then, of course, we have our chief judge, Judge Phil Davis. And he'll probably want to give you some salutations. And if you want to use the microphone? No.
Can you hear me in the back? Okay. I'll try to speak up. I'm trying to keep this short because I want to really begin the informal portion of this, which is hearing from you. I do want to thank all the judges that are here. I've been on the bench for about 20 years. I've been in the community for a few years longer than that. And I'm here to tell you that the judges that you see standing over there and sitting up here are the finest judges I've ever worked with. And that's I'm not saying it, and I wouldn't say it unless it's true. The reason we have the finest judges is because we have the finest attorneys. Some of them are sitting out here in the audience. Frank Sladek, the attorney's office. Andrew McCain from private practice sitting back here. We have Mr. Rick Gallagher. Are you retired yet, Rick? No. He keeps asking me when I'm going to retire. It's coming up, but it's always good to see Rick. And of course, Robert Folsom, our general counsel, who keeps us all out of trouble. Thank you, Robert, for what you do. I think you covered the ground rules quite well. One thing I want to talk about from my perspective, some people say, well, how do you become the chief judge? Well, I thought about it, and the only thing I can tell you is we drew straws, and I got the short straws. And so that's how you become the chief judge. But seriously, what happens is typically it's the most senior judge. As you can see by my hair, I'm definitely the most senior judge around. But it's usually the senior judge, not by necessity, because you can have a less senior judge who is selected as the chief judge. But usually it's because you want a judge who's done so many different things, and they have the experience to try to do what we do. Now, some people want to say, okay, well, can the chief judge overrule one of these judges over here? No. That's what we have appellate courts. What the chief judge normally does, I'm finding out as I go along each day, it's really like herding cats, I think, sometimes. I think we have some great cats over here. But they are all constitutional officers. Seriously, they're all constitutional officers, and we're equal is the best way to put it. I do have the power of assignment, and we have some new assignments coming up, which I can change. But that's one thing that the chief judge does. We do a lot of meetings. We make sure that our courthouses, we've already heard, judges from Baker County on the Georgia border, Bradford County, Union, Gilchrist, Levy, and of course Alachua County. So they all have courthouses, they all have problems, and we're trying to make sure that the roofs aren't leaking, the air conditioning is working, and that's something that the chief judge wants to be involved in. We want to make sure that these judges have the resources to provide the services to you. The last thing I want to do, I'll wrap it up, is some people ask me, well, do you like your job? I said, no, I don't like my job. I love it. I can't think of a better job to do than serving you, the members of the community, because we are public servants, and every one of them have the same attitude that I do. And we serve the Constitution. And I can't think of a better job. And every single day, we live, breathe the Constitution. I think if you ask any of these judges, say, yep, I ruled on that today, I upheld the Constitution yet again. And so that's something we all take our jobs very, very seriously. Hopefully we don't take ourselves too seriously. We trip on our roads too. We get our roads plowed to the door handles, that kind of thing, and then we'll laugh about it. Do that. But that's the last thing I want to say until we open it up. And you'll have each individual judge.
Well, no, they're telling me no. Okay. All right. So we're going to get started then with Pena. All right. Perfect. Thank you, Chief. So we'll go ahead and get started. Now, tonight it's going to be an overview. It is not designed to be a master class, all right? Because we have to be here to lobby tonight just for these three areas. We'll discuss what happens when mental health intersects with the court, and we will do that through a discussion of our problem-solving courts. And I'll use the term problem-solving and treatment courts interchangeably, but it's really the same thing. Now, Judge Pena is going to start us off with a discussion on the petition for involuntary examination under the Baker Act proceedings, which is Chapter 394. It's an act from 1971. And then we will move into a discussion having to do with Alachua County Drug Court Program and the Alachua County Mental Health Court Program. Both of those courts are line-funded. Finally, we will end the evening with Judge Pena, who will have more of a conversation with you about the uniqueness of veterans treatment. And due to the need, mental health and substance abuse and other services are available in all three of our problem-solving courts. So mental health can be addressed in other ways as well, but tonight specifically, we are going to focus on problem-solving courts. I'll hand it over to Judge Pena.
good evening, folks. My name again is Phillip. I'm a circuit judge here. It's my privilege and honor to, I'll begin by just saying about Veterans Court. I am the Veterans Treatment Court judge. It's close to my heart. It's important to me, and I know it is important to the community. And by the tail end of our discussion, hopefully we'll have a chance to talk about that a little bit. The first thing I wanted to talk to you, and I'll get right into it because I'm a little concerned when they said this isn't supposed to be a long version of what the law dictates in regards to Baker Acts. It's a really important part of the law. I'm going to try to go through this quickly. If not, someone over here is going to grab me and pull me back down to a chair. She also told me just at the side that I couldn't wear a tie today. I needed to be more personal than that. So we'll do that. All right, so Baker Act. So I've been told you that 394 is the Florida statutory section that deals with Baker Acts. We're going to talk about the elements of what you need for a Baker Act. And in essence, it's basically someone who's dealing with a mental health crisis, that they don't have the ability to make a decision as to whether or not treatment is actually necessary for themselves. And one of two other things may happen. Either they may suffer from neglect if they don't get treatment, or they may cause bodily injury to themselves or to somebody else. But we'll get into that a little bit more specifically here in a moment. Where does the name come from? Background, this is getting too far into the weeds, but basically in 1971 there was a state representative down in Miami who was very concerned about the status of folks with mental illness. And she was concerned about their due process and basically just locking folks up when we found out that they had mental health issues. And she wanted to put in a process that would allow us as a judiciary, as a system, to make sure that people are treated fairly, appropriately when they're getting the treatment that they may need. And as was said, it was back in 1971, was the precursor to what we deal with now today. So, not to become a professor, so let's get to really the crux of it. There are three entities that can deal with getting someone involuntarily examined. Okay? Three of them. One of them is the court system, right? So the court system, the circuit or county judge, can get a petition, normally 5% of the time it's through a petition, that someone files under oath to tell the court of some things that are going on with an individual to see if that individual qualifies for an involuntary examination under the Baker Act. Okay? It's ex parte. Ex parte means that the person, the subject of the petition, isn't present. They don't provide input at this point. And that's why it's important. That's why I take this incredibly seriously, because we're concerned about mental health, but we also have to be concerned about the liberty interests of folks. I would be authorizing someone law enforcement, to go pick up a person against their will and get them examined. That is a big deal, right? So I take that responsibility seriously with the backdrop of understanding and knowing that their mental health issues are concerning to me for their own safety and for the safety of the community. So it's a real tenuous balancing act. So let's assume that the order gets signed. Just a couple of tidbits for you. It can be enforced 24 hours a day, 7 days a week. Why? Because it's crisis, right? We want to get to that person as quickly as we can to get them the help that they may need. Next, a couple of things. The law enforcement can use reasonable force to go into the location in which the person is, again, for the same reason. This is a crisis situation. We want to get them the services quickly, no matter where they may be. And then lastly, again, tidbits of information. If the order doesn't say how long the order is good for, it's automatically 7 days. But the order can include in there how long it will actually last. And if it goes past the 7 days, you have to come back and reapply. Yeah, at the end, if you don't mind, just because I'm going to try to get through this quickly. I'm going to do it quicker. I'm going to try to do it quicker. So who can file that petition? Right? The petition is filed, the statute basically is pretty clear. Any adult who has the information necessary for the court to make that consideration, right? And so that generally is not an issue. But what you're going to see in most of the petitions, these are the folks that generally I'll see filing a petition: a parent, relative, a spouse, somebody generally who has some information about the person beyond just the episode that is going on now. So they have a comparison. They have something to say, well, look, I know this person normally, they're not acting appropriately, here's reasons why, things of that nature. When I see things of that nature, that means I'm trying to get serious. All right? So, all right, so who else? So what we've established so far is the courts can do it based on a petition primarily. The next entity that can do it is these gentlemen here, law enforcement. Law enforcement has the authority under the law. If they believe that somebody meets criteria for a Baker Act, they can initiate a Baker Act exam. take the person into a receiving facility and get that examination started through that process. They don't come to the court for that. Slight change in 2024 gave law enforcement some discretion. In the past, pre-24, if they met Baker Act criteria, boom, automatically you have to take it. Now, a little bit more discretion if law enforcement can see a mechanism or a way to sort of alleviate the crisis immediately, then they may not have to do it, and it's giving them some discretion. But I think it's an important notation. And then lastly, of the three entities that can do this are, as you can see, medical providers of various types, mental health, physicians, nurses, all the like that you see there that are named. And what they would do is they would execute a certificate. So they have to say, it's true, and I know it would be, that within 48 hours they've evaluated that person and they believe, as a professional, that they meet Baker Act criteria. And then that doesn't go back to the court. That is sufficient in and itself for them to contact law enforcement and for law enforcement to utilize that to initiate the Baker Act involuntary examination. Okay? So we've got those three entities. So let's get to the crux of what it is that you have to prove or show the court in order for an involuntary examination to take place. There's got to be a reasonable belief that the person has a mental illness. Right? Number one, starts with a mental illness. Number two, because, and that because is important, because of that mental illness, a couple of things must apply, right? That the person has refused voluntary treatment after it was explained to them and it's not reasonable. That's stemming because they have a mental health issue that's at hand. Or the person is unable because of the mental health issue to make that determination on their own at all. It's a slight variation, a slight difference, but it's nuanced, but there is a difference. So one of those two need to apply. And then secondarily, once one of those two is the wonderful end, one of these two things have to apply. Either without treatment, they're going to be neglectful of themselves and there can be a real and present threat of substantial harm to them because of that neglect. Or there's a substantial likelihood of serious bodily injury to themselves or to somebody else. Okay? So one of those two prongs have to be met. But this is important in the near future as evidenced by recent behavior. Okay? So it's not past stuff. Hey, he or she did this way back when, and I'm concerned they may do it in the future. No, give me the facts now, what is going on now, to indicate to a reasonable person, i.e. the court, if it's a petition, that something is imminent, something's going to happen right away. Okay? Examination period. So now we've got to the point of one of those entities has taken the person to get an exam, right? What's that period? It's 72 hours for that process to take place. Person, and that starts when they get to the receiving facility. Okay? Slight difference with juveniles, the exam has to be done within 12 hours. Typically for adults it's done within about 24 hours, but the 72-hour period applies to both. Okay? And this is somewhat of an important note, I guess. There is not a different statute for minors in Baker Act as adults. It's all pumped in. However, there's various points of importance that relate to juveniles or minors that do not apply to adults. And we'll talk, maybe if we have time, a little bit about that. Okay, so within that exam period, one of the following must take place. One of the nuanced things, one of the things that complicates things is if somebody is in custody. So I'm going to kind of stay out of that route because that causes a really long discussion. So I'll do it kind of more quickly. And that is that one of these four things is going to happen. The patient is released. Maybe they didn't meet Baker Act criteria after the examination took place, right? Maybe the person voluntarily agrees to do outpatient treatment. So they do the evaluation, they figure out there is some issues. Maybe it's not that imminent right at this point, but we don't want them to slide down a slippery pole without help. They may be a danger to themselves, so maybe they voluntarily agree to that. Maybe they ask for informed consent, so they stay as a patient. If they consent, they stay as a patient, wonderful. If there's an examination, then finally, and it reveals to the examiner that, in fact, there is a need for services, but the person does not consent to that, then you've got to come to the court. You've got to come back to the court. And that's a petition for involuntary treatment now. So now you want to place them either outpatient or inpatient. So that's generally the process that works in that manner. Criteria for involuntary outpatient services, we're going to do this very quickly. You're going to see, you're going to note the similarities to each of the standards. Again, the person has a mental illness, we're always going to start with that. That's what all Big Rap's about, is mental illness. Not substance abuse, not medical conditions. For outpatient, they're unlikely to voluntarily participate in the recommended treatment or service plan. Or unable to determine if that plan is even necessary for themselves because of their mental illness. Everything links back to the mental illness. So you can have a mental illness and not do things, but it's not related to your mental illness. You just happen to have it, and you just don't want to do it. You don't want an evaluation, but you're cognizant, you're knowledgeable enough to make that decision. Big Rap's not going to apply to you. So it's got to be linked to the mental illness. They're unlikely to survive safely in the community without supervision. Based on their history, there's a lack of compliance with treatment in the past. The person is in need of involuntary outpatient services to prevent a relapse. Again, to slide back down that hole, if you will, to the position of needing services inpatient because they may harm themselves or they may neglect to care for themselves in an appropriate way. And the person is likely to benefit from the involuntary outpatient services. Here's the reality. Are there that many outpatient? Who has dealt with Baker Acts in any fashion at all? Okay, fair amount. I think you probably would know. There's very little of the outpatient, right? The outpatient request. And the reason for that is common sense, one part of it, and the other is the statute's well-meaning, but it doesn't really give you the appropriate guidance to get things put in place. Number one is how are we going to get this person, who's going to monitor, number one? How are we going to get the person to treatment? How are we going to ensure that the person actually takes their medication? How are they going to come to court so I can monitor to make sure that they're doing what they said they were going to do based on the contract? All of those become issues. So it becomes really this issue. Are they likely to benefit from the involuntary outpatient services? Well, if they don't go, the answer to that question is no. So if they meet criteria, they're going to move to what is more likely, which is the inpatient. Involuntary inpatient. Okay, mental illness again, refused voluntary inpatient placement, even though it was explained to them, they don't have the ability to make that decision because of their mental illness. And then here, they're incapable of surviving on their own without treatment, likely to suffer from neglect, or the same thing as before, or there's a substantial likelihood that in the near future the person will inflict serious bodily harm on themselves or others. So that's what they're needing to present to the court and show the court to allow the court then to enter another very intrusive order saying you don't want to do this, but not only am I giving you an exam, but now I'm telling you you've got to stay in for treatment. It's tough. All right. Burden of proof. The first thing when I'm looking at just to get the exam, the standard is reason to believe. It's actually less than probable cause. It's reason to believe that those factors exist. That's when the petition comes in and the court reviews it. The other burden of proof for the actual outpatient or inpatient treatment is competent substantial evidence. A higher level than probable cause, not as high as beyond a reasonable doubt in the criminal division. In between the two, it's a standard that the court has to utilize again to make the findings of the factors that we just discussed previously. All right, so some issues with petitions. This is where I think some folks, especially the public, why was it denied? Or why was it granted in a different way or something of that nature? Maybe it just doesn't meet the legal requirements. It's not in that petition. It's not written down. I can only go on the petition. There's conclusory statements. The court is making a decision as to whether or not a mental illness exists. You as a petitioner are telling me he has or she has a mental illness or she's crazy. That's you. You've made some kind of assessment. I can't make an assessment based on that conclusory statement. I need the facts. What leads you to believe that? So I can make that assessment on my own. That's what the court needs to do. Remember, the court is not making a final medical diagnosis. I know you don't want me to do that, right? I'm not a doctor, right? I'll call my wife maybe. She's a doctor, but that's a side note. I'm not a doctor. I don't make those decisions. I just use the facts that you provide to see if there's a reasonable basis for the conclusions that the court will make as to the elements that have to be proven. How do you do that? People say, well, what if they've never really been diagnosed with a mental illness? That doesn't matter. You don't have to be formally diagnosed with a mental illness. You need the facts. And here's just an example, some observable things. Someone says that the FBI implanted a chip in me. Well, that might be some signs of delusion. They're talking to people who aren't present. Maybe some hallucinations. Not guaranteed, but something to consider. Describing. Here's the emphasis that I would have put in different colors. Describing. It's all, you have to describe it. You can't just tell. You can't just say they have disorganized thinking or there's mood instability. You've got to describe it so the finder, i.e. the court, can make that decision on himself. Oh, maybe the computer's telling me that my time's up. Here it is. Just some other examples: being angry, intoxicated, difficult family conflict, not enough, alone. Remember, the court is asked, does the dangerous behavior stem from the apparent mental illness? Again, everything ties back to the mental illness. Or is it caused by something else, unrelated? Intoxication, personality conflict, criminal behavior. If it's just those things, not enough. Mental illness. Everything comes back to mental illness. Again, some other examples of insufficiencies. Those are conclusory. What I said already, you don't have to be formally diagnosed. If it's just substance abuse, that's insufficient. Or if it's not imminent, there's no danger that's shown imminent based on the facts. Okay, last couple of examples. He threatened to jump out of the car. Well, what does that mean? If that's all the facts that are there, is the car moving? Right? If the car's not moving, did he jump out of the car because you just got him angry or her angry and has nothing to do with mental illness? You've got to tie everything. So as an example of what it would look like is while skating with the invisible man was chasing him and that he needed to escape, he attempted to open the car door moving at a certain speed. Now that establishes everything. There's a context of potential mental illness. There's an imminent risk of harm. The car's moving at 45 miles an hour. All of that's there for the court to make some kind of decision. Some other examples that. All right, so examination process, they take it to the facility. We know that 72 hours, 12 hours for the exam for minors. Do they meet involuntary or voluntary criteria for services? And then what are they considering? They're considering the personal observations of the patient, the detailed review of recent behavior, the documentation from the petition or whatever is presented from the medical provider or from law enforcement, their history, face-to-face examination. All of those factors are considered by the evaluator to come to the court with whatever decision they ultimately make. And they'll have a physical exam automatically to make sure that it's not a medical condition rather than a mental condition. This will bypass, as you already know what happened, is the options. They don't have a mental illness. You can't seek a Baker Act. There's mental illness, but the other criteria isn't met, so they're not dangerous. It's not found that they're dangerous to themselves or to somebody else. And then thirdly, mental illness and the criteria is met, and that's when you need to determine to come back to court to actually seek involuntary treatment. All right, the hearing takes place 5 days after the petition is filed. It's presided over by a judge or a magistrate. In our circuit, we have great magistrates, and they handle the initial proceedings. There's no jury. There's a right to an attorney, right to be present, right to present evidence and witnesses, right to cross-examination, right to testify or remain silent. All those are hearing aspects. You'll hear from the psychiatrist. There'll be clinical findings. All of this is placed and discussed during the course of the hearing. And these are just the same factors, again, that we already talked about. That's the evidence that needs to come forward. And you'll generally have the ability to hear from family if that's something that may become relevant in court. When we talk about clear and convincing evidence is the burden. We know about the possible outcomes. We're going to bypass that. We talked about that. But whether it's denied moving forward or not. But this must be important, since it's important notice. The hearing is not criminal, right? It does not create a criminal record. Patients can appeal the court's decision. That can be reviewed by habeas corpus review, challenging the unlawful detention or failure to put a closing parenthetic. That's not good. I think I'm probably running a little bit short on time, so I'm going to bypass the full discussion about minors. But minors is an interesting aspect. Parents do not have to quickly go into a Baker Act initially if they're concerned. They can take their child to a facility to check them out if they have a mental issue concern, and their admission into the treatment facility is the initial consent. However, once the evaluation is done, and if the minor says, no, I do not want to stay, then that triggers all of the protections that we've already discussed. And you've got to go through the whole take-out petition and deal with that aspect of things. Anything else? Real quick before. Minors, yes. And then it's the somewhat boring stuff that no one wants to hear about, and that's the facilities and how they're dealt with. Some of the local facilities that we deal with here related to okay? So if you have a quick question related to Baker's, I'll answer. Yes, sir.
I wonder how adjacent curious the states those first people and the experience of quickly providers who are saying very surface. I wonder how we can use this traumatizing people maybe in the position on this is not a good question, but how do we not shove grief and
recycle here?
into these
let me cut to the chase, and I looked at a friend of mine there in the audience, and many of the people here know that I've suffered a lot of grief recently, a lot, and it's always a concern, and by all of these judges and all of the courts, to make sure we're doing the right thing based on the information that we have. Right? That's all we can base it on, and so the checks and balances on the hearings themselves. The evidence, the fact that the person who's been evaluated and determined whether or not they need the involuntary treatment, they have their attorney. And that attorney has the opportunity to actually even get a second opinion.
how is there a hearing?
No, you're absolutely right. That's why I emphasize the ex parte portion, the original examination portion. That's why it's a stickler for the rules in terms of the petition itself. And sometimes it's very difficult. I make these decisions quite often. And sometimes I don't grant them, clearly, because it's not enough legally on the documentation. And I will say this just generically because I have no problem with this. When things are denied, there's generally information in the order indicating what the deficiency might be. And everybody has the opportunity, if they wish, to remedy that, if they can. It may or not be. So I guess the short and long answer to your question, which is not easy to answer, is That's fine, no, that's fine. You do the best you can with the information that you have, with the overriding concern of the safety of the individual, of the community, and understanding that there's liberty interests that's being curtailed.
What is the measure, the amount of provider, like, who looks at control? This really small phone maybe with another much more state and somebody who's like, hey, how do we these different people who are
No, I hear what you're saying, that in the ex parte portion, it's just going to be based solely on the four corners of what's
But
presented.
one of these is just scared of families, you know, because if you don't get things, I hear something about their group of colleges.
I hear you. That's a good question. Appreciate it.
Great question. I've also been asked to remind everyone, even though some of you are parked in the parking right up behind the building, make sure that you leave when we're finished at the end of the evening, because otherwise you will be locked in. Okay? So don't go downtown and leave your car in the nice, safe, secured parking spot because you'll be locked in. All right? All right. So I've made that public service announcement. We'll get back. Let me see. Can I get the clicker? No? You kept the clicker? It's in your hand. No, that's your glasses. All right, there we go. Clicker, starting. All right, that's Judge Pena and me. Looks like a few years ago, actually. All right. Okay, so problem-solving courts. Now, about us. These courts are designed to tackle the root cause of criminal behavior through a collaborative group approach, which involves stakeholders. That's a lot of information. The Florida statutes prescribe and outline the parameters of these problem-solving courts, the participants, who will be the participants, and what are the procedures. Now, in Alachua County, we have Veterans Treatment Court, which is Judge Pena. That's part of his assignment. Drug Court, which is a part of my assignment. Mental Health Court is also a part of my assignment. We also have Mental Health Court in Bradford County, which is covered by Judge Tatum Davis, and Levy County Mental Health is covered by Judge Sherry Lancaster. All right? We'll keep going. Now, all of these courts that I just talked about, again, have an overlay of mental health. Now, facts. I bet you didn't know Dade County led the United States in drug court. It was the first drug court in the United States. And ever since then, they've served as a model to different states. As of October 2025, we have approximately, it actually should be, that's my typo, it should be 33 instead of 34 mental health courts around the state of Florida. And we don't have the stats for 2025 participants, but we have somewhere over 2,400 participants statewide. As far as drug courts, we have approximately 49 drug courts around the state, and that includes juvenile drug court, dependency drug court, and then of course adult drug court. Now, everything that I'm talking about in my portion has to do with criminal cases. Judge Pena's Baker Act is civil, all right? Now, so I've done that. And in 2024, there were a little over 3,300 participants statewide. Now, who are these folks? These are the stakeholders I was just talking about. So, 8th Judicial Circuit, that's the court. The State Attorney's Office, the Public Defender's Office, Alachua County Court Services, and all the way down here are the defense attorneys from the community, and all the way down here are the treatment providers, right? So I'm going to weave in a little bit of your question, in, or maybe an answer in an abstract kind of way. So listen closely. So what happens is we have these stakeholders and the treatment providers, who are folks like the mental health assessor, the addiction specialist that meets with the participant. Alachua County Court Services, the group right here on the end, they provide staff and funding for our programs. They have staff that monitor each participant's progress. They contact the provider to make sure that the participant is actually abiding by the court order, that they're following up with the providers, they administer drug tests, and they even obtain bus passes for these folks, so the participants, so they can actually attend their appointments. All right. We have felony drug court, services, group and individual therapy, support groups, random drug screens and/or case management, the philosophy, rehabilitation for individuals with substance abuse problems. It reduces recidivism, alternative to incarceration, therapeutic rather than punitive. Now, we're going to dive in a little bit. The participant is identified at the earliest possible stage. Now, as a county court judge, we hear our major assignment, or part of our assignment, Monday through Friday, we hear first appearances. And those are the first hearings that a person will have after being arrested within the 24 hours. And we try to keep our eyes open. We read the facts for a multitude of different reasons. One thing we also look for is this person exhibiting mental health behaviors while at the jail? Are they wearing a specialized uniform that triggers to us this person is experiencing mental health? Is this person appropriate for mental health court? Is this person appropriate for a drug court? And we're processing that along with everything else we're doing. So we may release that defendant to a program, like drug court or mental health court, or we may set a bond for that person to be screened by one of the mental health court or drug court or veterans treatment court staff. Now, the state attorney's office must approve the participation. And let me also add in there, if we don't see that this particular defendant is appropriate for one of the problem-solving courts at first appearance, there's also the arraignment 30, 45 days later. Or the defense attorney for that defendant can bring it up at the court and say, I'd like my client to be considered for one of the problem-solving courts. It happens all the time. I get on my computer, I shoot an email to the liaison and say, please contact this defendant. If the defendant's in the jail, they go to the jail to see them. Now, there's an administrative order from our chief judge that abides by the statute, and it outlines who can participate, who cannot participate, what the program entails, and it outlines everything that we are permitted to do in our treatment programs. Now, for instance, for felony drug court, you have to be charged with felony. Now, if you also have a misdemeanor case, that's fine too, but you must be charged with felony. And mental health court, you must have a mental health diagnosis. You must be competent, and there must not be an issue of competency. Your competency cannot be put into question, all right? Some folks are ineligible for these programs. For instance, no DUIs, no domestic violence, no serious or violent offenses. You cannot participate in our programs, problem-solving programs with those type of backgrounds. And finally, if there are victims in our cases, then the state attorney's office has to obtain approval from that victim for the defendant to participate in a problem-solving court. Sometimes that takes a little bit longer than we had hoped, but that's what they're doing. These courts are non-adversarial. That means what? Who knows? No arguing. The lawyers are not going to argue. Oof. Okay? They're not going to argue. They're not filing motions, and they know that this case is not going to trial. Because at that juncture, it's all about treatment. It's treatment. Now, problem-solving courts are voluntary. You know how that works. That's like telling your child, you can't or you must, and I remember seeing a cartoon or something and it says, I'm going to do it sitting down or standing up, whatever it is that your child would say that would be defiant. Not my kids, they were wonderful children. But, you know, treatment only works if you want it. So that's why the problem-solving courts are voluntary, all right? And here's how it works in real life. There is something called informed consent. Someone from the Alachua County, did I get ahead of myself? We'll stay there anyway. Someone from the Alachua County Court Services will go out to the jail, meet with the defendant, and talk about frequently asked questions and attempt to give them the responses so that they can make an informed consent about whether or not they wish to participate in drug court, mental health court, or even veterans treatment court. If the person is out in the community, if they've been released, then court services will schedule an appointment to meet with them and talk with them. The next step is level of care, if they're interested. Level of care, an appointment would be set up for them on their behalf. They'd go speak to that addiction specialist or the mental health professional, and that professional tells us what level of care this person needs. And that's where we have the plan of whether there's going to be AA class sessions, group sessions, or individual counseling. That's where we know what is recommended for this particular defendant. It's not a one-size-fits-all. The participant must attend whichever program it is that they're interested in, they must attend those hearings. Usually they attend 2 or 3 of them. Then they get to see real time whether or not this program is for them. What are they signing up for? You know, is that judge off her rocker? And, you know, what am I going to do? What's going to happen? What are the possible sanctions? They get to see all of it. Let's see. The services are individual counseling, group counseling. Sometimes we start off with group counseling, and then we realize information is being disclosed, and the provider says this particular person needs individual counseling. And it may be to address grief, right? And that's in every one of those problem-solving courts. So drug court, the primary issue is misuse of substances. But there are this overlap of oftentimes mental health. There's a reason oftentimes why there's a misuse of the substances. So when we're finished with whichever court it is, the hope is that that person is made whole. All right? There's medication management, there's anger management classes, there's outpatient, inpatient, residential drug treatment. Okay? Now, length of the program. Here we turn the page. Once the defendant is admitted into one of our treatment programs, they're telling me I have 10 minutes. We're not looking back there, okay? Once a person is admitted into the treatment program, they're no longer called defendants. They're called participants, all right? We all call them participants. We switch gears. Upon admission, they sign a contract in open court. And in that contract, it prescribes or it outlines their responsibility, the type of services that are going to be provided to them, and it just explains all the rights and responsibilities, as well as the sanctions, because you need to know that sometimes the court might say, you're going to have to write an essay because you were late twice this week for check-in, and then it gets progressively more serious, okay? There will be hearings. I will take the case from whichever judge is assigned to it and transfer the case to my division, and I become the trial court judge. Now, we have staffings. The judge is a part of the team. So, who is the team? All those folks that you just saw earlier. The defense lawyer, the state attorney, the treatment provider, it could be the mental health counselor, the anger management person, a provider. We all sit and talk about progress, problems, struggles, deficits, new issues. The court's role is a little different in these type of cases. The judge is the leader of the team. We set the tone, the tenor from the top down. We speak directly to the participant. When we're in court for a criminal case or a civil case, the judge only speaks to the lawyer. And the lawyers speak to each other. Well, that might create a problem. They speak to the court, right? But in the problem-solving courts, the lawyers are seated and the judge speaks directly to the participant. You've done a great job. You slipped up this week. You were late 3 times, but we know you can do it. Tell us what the reason was. So we have a conversation. It allows us to put on a completely different hat. We encourage progress. We address any relapse, and we do it timely. Because if you can remember, and I'm going back to kids, because like I said, mine were perfect. So when I say that with sarcasm, it sounded like, right? But you know, when they did something wrong, you really have to address it right away, because if you talk about it 3 days later, they don't even remember what they did. So it's the same thing in the problem-solving courts. If there's a problem, somehow the liaison in our court administration can find Judge Pena and I, even if we're on the moon, there's a call on our cell phone that says, I need to talk to you. Can you give me 5 minutes? All right? We hold participants accountable, yet maintaining the integrity of our treatment programs, while also keeping in mind it's also our responsibility through these programs to protect the safety of the public. There are incentives for participants who are successful and are doing what they're supposed to be doing. We put them on the 18. I know that shows my age. I don't care. Okay? We put them on the 18. So when they have court, they come in, and literally in 10 minutes, we recognize the group of the 18. We reward them and, you know, give them props for things that they've done well. And then off they go to whether they're going to their counseling session or they're just going to have lunch. It's a whole team approach when we staff these cases. The judge, the providers, the court services, the whole team makes the decision. Now, length of the program, it says 14 to 16 months. Most people, it's 12 months. But I will tell you the 3 phases. First phase, 30 days. Second phase, 150 days. What happens if at 149 there's a positive screen? We hit reset. You start phase 2 all over again. So I'd like to remind the participants when something like that happens and they literally want to become unglued, I remind them, you know, the Prime Minister of England once upon a time, Margaret Thatcher, said, sometimes you have to fight a battle more than once. So now you're on day 1. Okay? These programs work. Graduation, family members, friends come in, and we celebrate with them. I remind them who they were, what they acted like before they started the program. And their family tells them the same thing. So, I mean, short of like cupcakes and balloons, which we've never done because there's an administrative order that says we can't do that stuff. I'm just looking at the chief judge, sorry. I'm just kidding, but you know, we have to take care of the courthouse. But one of the things that happens is, a part of that contract, the state agreed that they would dismiss the charges. And the charges are dismissed right there in open court, and a copy of the dismissal is handed to the participant right there in court. Now, in some cases, there's a plea agreement that prescribes that whatever the plea agreement is. We don't have those all that often, but when we do, the state will abide by whatever the outcome is on that plea agreement. But the case is over. There are services available for after graduation in case someone, you know, 5 years later, 3 years later, they need additional services. It's there. Now, I've given you the meat of all of this. Mental health court. It's the least restrictive treatment, training, and support services are necessary to reduce recidivism and ensure public safety. It is designed to divert the mentally ill and developmentally disabled from jail and to expedite legal cases that proceed through the criminal justice system. system. The criteria, we've gone over it. You must be diagnosed with a mental illness, charged with a crime, and you cannot be mentally incompetent. Referrals. Anyone can make a referral. Anyone. The length of the program is 9 to 12 months. 3 phases, 30 days, 150 days, and 90 days. Those are the 3 phases. Now, we have graduation. So for mental health board, and like I said, there is an overlay of mental health in all 3 of our problem-solving boards. But on graduation day, I always ask, especially for mental health board, bring your, significant other in, your parent, whoever it is that usually accompanies this participant, and I ask them, tell me how he or she was before they started. Tell me what you see now. And usually it's tearful. The progress, the changes are evident. And I also ask the participant, how do you feel now? Tell me how you felt, can you remember how you felt back then? And they go ahead and they tell me. And then I remind them of the notes that I've been keeping in the court file during our hearings and the changes that I've seen on, with their behavior. And in the words of the great theologian Bob Marley, you never know how strong you are until strong is your only option. So graduation is an exciting day, and the state will dismiss those charges in open court with a copy of the document handed to the participant right there in court. Now, that is it for my portion, and I know that I'm 2 minutes ahead, but do you have any questions for us that myself or Judge Pena can answer? No? One?
Is the public permitted to call the office of judge and request a meeting just to talk? Our family suffered internal family tragedy some years ago. Our son is on the spectrum, has comorbid mental health issues, and we feel as though there was a prejudicial prosecutor, and he was denied mental health court despite the folks at Meridian, and when he was evaluated, they said either complications or the mental health court. And despite our pleas, and we had copious documents showing that he had mental health issues.
So we can't give the legal advice. I can only encourage you to speak to a provider.
So my son's episode was because he had a negligent psychiatrist who screwed up his medication, and he had a psychotic break. She's been fired and reprimanded, and this is several years ago now, and it's all behind us. But I just want to know if there are there mechanisms in place now that protect people with mental illness, protect people with autism, so that when a family member, and when it's something that happens within the family circle, and the family says, this needs to be dropped, these are the reasons why, the family presents documentation. I just want to know, is there a mechanism to protect families and mental ill from being railroaded through family courts?
I don't know that I can answer that in the affirmative. I can tell you, in the University of Florida, if I'm not mistaken, I can't recall the name of the program, where there is autism, the spectrum. What is it called? CARD. Thank you. Because we have also used that in mental health court as well as in drug court. And I know know that there are attorneys in town that could offer, I'm sure that there are attorneys in town that can offer legal advice, but I'm unable to give legal advice. As I said, it is part of our rules of conduct. We cannot.
I'm not looking for advice, I'm just
Well,
saying that since there are so many judges here, please, when persons on the spectrum and with mental health issues present, have an open mind and take the time to listen to the family and double check what the prosecutor is doing.
thank you. Thank you. We, our problem-solving courts, the participants can only enter the program if it's authorized by the state attorney's office. The state attorney's office is the entity that will file the charging document and decide how to proceed. But thank you.
I just want to add one thing. Again, that's the beauty of the treatment process, because what you're just alluding to in the family input and their background and their knowledge, that does come from your treatment. And that's the big divide, if you will. That information is going to come. Whether it's alone, I don't know if you really intended it to be alone. You know, I've had family members say, Judge, we'd like to give you more information about this participant in veterans treatment court. Contact the state, the defense, they have no problems with it, and we have that discussion. The more information you have, the better we can establish treatment. So I hear what you're saying in terms of getting the most information possible. But the initial process is all with, I hate to say it this way, it's not advice, it's all with representation that you may have had, and in terms of what legal avenues they have to address refile.
Yes, sir.
So I've been a beneficiary of several of the programs here in Alaska County. And Alaska County, we're leading the state, we might be leading the nation in all this stuff. I'm so grateful to live here. And at the same time, since I've stopped using substances and got into Narcotics Anonymous and started changing my life around, I started doing service in the prison system and the jails. And the prison system is great because they have the same rules for the whole state, but the jails are very difficult depending on the jail and the county that you're going to. Some of them are not as forward thinking as the Alaska County. And so I'm just looking for suggestions when I'm trying to get people who are Narcotics Anonymous members to bring in meetings where they don't have meetings and they desperately need them. What can I do to write letters to judges and write letters to sheriff? What would you recommend would be most effective to help me get needed services coming because I'm not sure?
So let me just say that let's talk about practicalities. Right? Some of the practicalities are, yes, jails across the state are all in different programs, different abilities. One of the main issues is their funding. Do they have the ability to bring in services? Do they have the funds to have the appropriate level of security when those things happen? You go to smaller counties, they're not going to have that. Miami-Dade has probably most of all of the circuits, all of the programming within the jails. Some of them are astounding, it amazes me.
And there's staffing too.
Is that
Funding and stuff.
going to occur in other counties? Probably not. It's very difficult. There's other avenues to address that. In the near future, there will be other meetings to discuss sort of the process. One of the issues that I would have brought up with Veterans Treatment Court and its acknowledgement, of course, we're constantly self-analyzing the program to see is it working? Do we need to tweak it? Who can provide more information to help us make it better? And so that may be something that's not just
I think we have time for one more question. All right, so maybe two. Right there.
Growing up, saying that you were going to bake rack somebody up kind of dirty work, you would say, oh, don't bake rack. How often, in all of your experience, does bake racking and voluntary treatment make a person's condition significantly worse?
I can only base it on obviously the cases that I've handled, and I haven't seen it making it worse. However, I will tell you the truth. The truth is once the treatment component is complete, if I never see the person again, I won't know long-term what has happened. But I only know up until the point that I've been asked to intervene or to provide orders or the like. difficult to know the long term. There are statistics out there, though, that indicate that it's not as prevalent as I'm not sure if you believe or concerned about. It's not as prevalent as you're concerned about. There's no doubt that it could happen on occasion. There's no question.
Because, imagine the Baker Act comes about when you've decided you don't wish to have treatment, so a loved one is going to petition the court on your behalf. The flip side of that is many people choose to get assistance, treatment, services on their own. So when you start to weigh, is it really as prevalent? And it may not be as prevalent because folks are choosing to do it on their own. So I hope that answers the question, sort of. Okay, one more.
I know we didn't touch on this, but it pertains to incompetent to proceed. Say someone deemed incompetent to proceed in Seminole.
That's a whole other night.
Yeah. They're deemed incompetent to proceed in Seminole County, and they receive medication. Why do we have to come to the East Circuit? Just because the location of the facility that's in,
Yes.
and we're not back to Seminole?
Because the body is here.
There's a side issue to that. I mean, it's just like folks who are in facilities that were sent from other counties to facilities in our circuit. And I've always said this. And there's some act that occurs, battery, whatever it is, we undertake the responsibility for that criminal allegation in our circuit, even though we have no ties to that person other than coming to this area in case that were from another court. But the venue is here.
All right, so I'm told one little question and then we have to wrap up. Is there give anything evil like that?
How can we best advocate to get a detox or medical treatment program in a lot of I come from other kinds of facilities where they had such cause and
Well, I mean, I don't know exactly what the sheriff's office has in terms of that. I know that there is for a better choice of words, a mental health unit within the Alachua County Jail. And I know that there are times when folks are going through withdrawals at the jail. Exactly how they handle that, I can't say that I've had a conversation with anyone there as to what their technique or procedure is. But it's a great question, and because the sheriff is running the jail, that
I had this conversation with Dr. William Wall last week. He said they started in recently.
good.
So I don't know what the substance is, but we were very surprised that such as that.
That's wonderful.
Either forensic, something or another.
Yes, I'd be happy to give you more info after the meeting. And we have been partnering with the jail to administer and implement the justice system.
Excellent, excellent. Ladies and gentlemen, I want to tell you thank you all so much for being here tonight.